Hello, and welcome to Legal Briefs. Come on in. Welcome to my humble abode. Give me 12 minutes and I will have you up to date on everything SEC versus Ripple. This week, it's the trial of the century. And then we can have a beer. I have Corona or Corona. Your choice. But before that, this week, Chairman Gensler was making the rounds with Congress and the press, and you may know that the SEC is an independent agency. It's really part of the executive branch, but Congress controls funding, so traditionally the chair of the SEC is very helpful when questioned by Congress. Until now, apparently. And here we have the questioning by Representative McHenry.
Is it your view now that that Bitcoin and Ether are not securities?
No, I'm not going to get into any one token, but I think the securities laws are quite clear.
Based on Commissioner Peirce's digital token safe harbor proposal, I asked about this before. Have you had a chance to review her proposal?
Commissioner Peirce and I talk actively about these matters, but I have not yet reviewed. I think you just introduced your bill this morning, and I look forward to looking closely at that.
But the bill is based off of her proposal, and I was asking if you've reviewed her proposal.
Commissioner Peirce and I have had a number of conversations about her thoughts on these.
Okay, so you're not willing to answer that question. Okay.
That's strange, but it's okay. Representative Emmer is up for questioning, and this should go much better.
Let's say you deem one of these coins with $1 billion market cap and tens of thousands of investors a security. What happens to those investors, sir?
Well, if the coin were to come in and to actually register, those investors get the benefit of our securities law. Right now, they don't have the benefit of that basic bargain that we protect people against fraud and manipulation in our capital markets, is they get full and fair disclosure. They're not getting that right now, and it's falling short, and people are going to get hurt.
Chair Gensler, actually, what will happen under that scenario is the value of the token will plummet, and retail investors, the very people you are supposed to protect, will not be able to trade in it.
You know, strange, that scenario sounds somewhat familiar. I wonder what crypto lawsuit Representative Emmer might be referring to.
Wouldn't investors be hurt by your enforcement actions? And what are you doing to solve this problem? What are you going to do?
What I've said publicly, and I mean this, is come in, work with us.
Okay, I got it. Crypto companies should just come on into the SEC and work with the SEC on it. I've got it. And I've actually heard Mr. Gensler say that before a couple of times.
If they come in, ask a question, and I suggest they come in, and something is a security, then work with us.
But if I recall correctly, I think that Ripple did exactly that back in 2018. They came on into the SEC to discuss XRP. Hinman talked about it in his deposition. In fact, here is a video of that meeting as Ripple's young general counsel went to the SEC for guidance on XRP back in 2018.
Welcome to my home. Enter freely of your own will and leave some of the happiness you bring.
But that was way back in 2018, the olden days of crypto with crazy ICOs and such. The SEC is much higher tech nowadays and conducts its come on in to discuss these things with us meetings with numerous market participants all at the same time. It saves on time a lot. And here's how that goes. Interesting fact, that first guy that was shot was actually named Coinbase. Get it? His name was Coinbase. Wasn't Gary Oldman amazing in Bram Stoker's Dracula? He was awesome. And here's Ripple's attorney, Michael Seresny. I think Keanu could pull him off in the Ripple movie. I really do. And speaking of Dracula, the SEC versus Ripple case must seem to you like it's the ever-living undead, but believe me, this case will die a natural death here soon, and I will hopefully be here to report it for you. This last week, the case had 3 motions and 2 orders filed, but there is one motion that is really important, and I'm going to let you know about that, and of course fill you in briefly on the others, and also the biggest order to date, which I will talk about at the end of the video, so stay tuned. First, we shall start with the fight over requests for admissions, which are called RFAs, and RFAs are requests from one party to another that demands the party admit something. Here is the rule for RFAs. It's Rule 36, Request for Admissions. This is Rule 36 of the Federal Rules, and in paragraph 1 it says that a party may serve on any other party a written request to admit. And then look at paragraph B. A matter admitted under this rule is conclusively established. So the purpose of RFAs is to narrow the issues that the court needs to decide. And like other discovery devices, the one interesting thing about RFAs is that there is no limitation on the number of RFAs that you can serve on the other party, at least not in the rules. And that is our area of conflict here, because Ripple served over 29,000 RFAs on the SEC, and the SEC did not like it one bit because, as the SEC complains, quote, "These requests impose an extreme burden on the SEC, specifically if a single SEC attorney spent an average of only 5 minutes reading and answering each request, it would require 104 days to respond," close quote. Now, I think that argument will be compelling to the judge, and the SEC has a lot of case authority to cite for the proposition that even hundreds of RFAs are too much. But Ripple filed its response on October 7, and it also cites a lot of case authority. But I was a little disappointed in the response, to be honest, because I think Ripple had a very strong argument in its favor of its 29,000 requests. And that argument is that the SEC waited 8 years before bringing the lawsuit, and that is why the lawsuit involves over 1,700 sales of XRP and contracts, and that is the SEC's fault for waiting that long. And although Ripple does say that in a roundabout way, it really doesn't take the opportunity to go Mortal Kombat killing blow on the SEC on that one. Scorpion wins. So in brief, I feel like Ripple didn't take this one home like they normally do, and I think they leave themselves open to having the number of RFAs from 29,000 trimmed down to some lesser number by the judge. But even if you see an order to that effect in the next couple weeks, which grants the SEC's motion, don't lose sleep about it, because it doesn't limit Ripple's evidence. It will just force Ripple to present the evidence instead of having it all admitted as an RFA. Yes, what I'm saying is that the RFA fight is not the important one. The main event here is definitely the SEC's motion to compel Ripple to search and produce more of its videos and audio recordings of their meetings. And we have now seen the briefs from both sides, so let's take a look. Welcome to the main event.
Let's get ready to rumble!
Every guy that hears that instinctively thinks he's a fighter for a second. All right, so this is the motion to watch out for, and here is what the SEC wants. Quote, "The SEC requests an order compelling defendant Ripple Labs to conduct a reasonable search of relevant video and audio recordings of internal Ripple meetings," close quote. So that is what the SEC wants, and we have made a big deal in past videos that it was a mistake to sue Garlinghouse and Larson individually for many reasons, but in this motion it actually helps the SEC, and let me explain. The reason it helps the SEC is because these are internal meetings, meaning only Ripple employees were present. So, how could these meetings be relevant as to whether Ripple had formed investment contracts with third-party purchasers of XRP it sold? Because these meetings were only internal. That relevance argument is difficult for the SEC because, well, it's not really relevant at all as far as Ripple. But remember, the SEC has to prove Ripple only made an investment contract, but as to the individual defendants, it has to prove that they knew that selling XRP was wrong. The legal term is scienter, and here's how the SEC says it in its brief. Quote, "The recordings Ripple has produced thus far demonstrate the potential trove of highly relevant evidence Ripple is withholding on the main disputes in this case. Whether Ripple's offers and sales of XRP are investment contracts and therefore securities under the Howey test, and whether Garlinghouse and Larson had the requisite scienter for purposes of the SEC's aiding and abetting claims," close quote. So if I'm the judge, I'm a little iffy on whether these recordings are relevant as to Ripple, but I 100% believe they could be relevant as to claims against Garlinghouse and Larson. And I think that wins the day for the SEC on the relevance of these recordings. And that is not good for Ripple. And for why that is, let's look at page 5 of the SEC's brief, where we learn that Ripple so far has turned over 85 recordings of meetings, and here is how the SEC characterizes them. Quote, "The recordings produced so far are highly probative of, among other things, Ripple's efforts to increase the value of XRP, Ripple employees' reasonable expectations of profits from Ripple's efforts, and Ripple's significant managerial and entrepreneurial efforts to maintain and further develop the XRP ledger, all critical evidence for purposes of a Howey analysis. See Exhibits F through I." And that doesn't sound good. Let's go take a look at Exhibits F through I. And here we are, and let's take a look, and oh, it's all filed under seal. But whatever it is that the SEC is referring to, I have a feeling that those recordings will form the backbone of the SEC case, and that is why whether it is able to gain access to more recordings is very important to the case, and so far things are not looking good for Ripple on that front. But we haven't heard from Ripple yet, and here is how Ripple counterpunches. Quote, "In short, Ripple undertook a comprehensive search for potentially responsive recordings and agreed to each and every one of the SEC's supplemental demands for additional recordings. Ripple's discovery efforts were plainly reasonable and have proven highly effective in identifying potentially relevant recordings. Rule 26 does not call for more. The SEC's highly disproportionate demand that Ripple now, more than a month after the expiration of fact discovery, review every single recording ever made over the last 8 years should be denied." Close quote. So Ripple is arguing that it complied in its discovery obligation and that the SEC's new requests after August 30 are too late because fact discovery window had already closed at that time. And because so much in discovery disputes is left to the judge's discretion, it's difficult to guess what the judge will do. My instinct is that she's going to want to allow the SEC to be able to dig a little bit further into Ripple's sandbox, and that feeling just comes from her prior rulings in this case. The problem the judge is going to run to is time. She's running out of time to scope really broad orders as a hard discovery cutoff is coming in a month in early November. Now that might lead to a denial of the SEC's motion, but my best guess would be a limited granting of the motion that would allow the SEC to get more recordings, but in a limited way. And last but not least, and most important of all, we have Attorney John Deaton news.
It's a chopper, baby.
Whose chopper is this?
Zed's.
Who's Zed?
Zed's dead, baby. Zed's dead.
Yes, apparently Attorney John Deaton will be riding his chopper straight into the Ripple litigation on behalf of XRP holders after all. And here is the order. Quote, "Accordingly, movements in their individual capacities shall be permitted to act as amici curiae in this action. As such, movements shall be allowed to assist the court by briefing legal issues relevant to the case as approved in advance by the court. The court contemplates that such assistance will be most beneficial during briefing on dispositive motions, but may exercise its discretion to request or deny further applications as appropriate." Close quote. So the court did what we expected, denied the motion to intervene as full parties, but allows for the filing by Deaton of amicus briefs, which will allow Deaton, at a minimum, to file a brief at summary judgment and present the position of XRP holders in the official court record. And why is that so important? Well, for that, let's take a look at this video from back in February of this year. This judge needs to understand that this case is not only about Ripple the company or about multimillionaire company CEOs, but about the potential devastating impact an adverse ruling would have on tens of thousands of people who are and have been holders of XRP for years, some who have put their life savings literally into XRP. And if Ripple can get the judge to understand that, I think we have a judge who is willing to get past the Howey test and get to the truth of the matter. And that, I think, is how you win this case. That guy makes a lot of sense. Too bad about his face. In any case, that part of the case, letting the judge know how this case has affected 30,000 XRP holders, check, taken care of. And again, much respect to Deaton for jumping into this fray. He wasn't a securities lawyer last year. Just a guy who saw an injustice and decided to do what he could. And maybe you too someday will jump into the fray just because you feel it's the right thing to do, and that's a beautiful thing. Thanks for watching. Well, hello, and welcome. The SEC, nowadays, it conducts its come on in and discuss things with us meetings with numerous market participants. The SEC is much higher tech nowadays and conducts its come on in and discuss. Boy, I'm having a hard time. So, if I am the judge, I'm a little iffy on whether these recordings are Yes, apparently Attorney John Deaton will be riding his chopper straight into the